This episode of Employment Law focuses on discrimination laws in the workplace, presented by Kara Bashutsky. In the context of human rights, it's important to understand the difference between provincially regulated and federally regulated workplaces. The vast majority of workplaces are provincially regulated. In Manitoba, discrimination matters will be covered by the Human Rights Code. For workers working in industries such as banking, telecommunications, transportation, typically the Human Rights Act will govern. While both sets of laws aim to prevent discrimination, they may have some differences in scope and application. We're going to focus solely on Manitoba's Human Rights Code. Workers in Manitoba may also have rights under these various laws, as you see, depending on the nature of the workplace and the issue at hand. Human rights legislation is given special status as quasi-constitutional legislation. Manitoba's preamble aptly captures the importance that we are all part of the human family. As our society changes, so too do our laws, and so will our interpretation of what this means. While we have come a long, long way, we still have a long way to go. Taking a brief step back through history, we see that the Fair Employment Practices Act was the first time that Manitoba legislated anything related to discrimination in employment. This predated the Human Rights Act and our current Human Rights Code, and as we'll see shortly, the Fair Employment Practices Act looked quite different from the laws we have now. 1953 was the first time that Manitoba legislated any specific laws related to discrimination in employment. This only related to race, national origin, color, and religion. As we see shortly, this is vastly different from our current Human Rights Code that protects discrimination in employment on a much greater expanded level of protected characteristics. Discrimination in the Code is specifically defined. It's essentially treating a person differently to their disadvantage, where it is not reasonable to do so on one of the protected characteristics that we'll see on the next page. Discrimination can also be failing to reasonably accommodate a person with one of these protected characteristics. In order to come under the protections of the Manitoba Human Rights, someone must first prove that they have a protected characteristic as listed in Section 9 of the Code, as you see here. This is not an exhaustive list. For example, disability includes substance use disorders, addictions, mental health conditions that isn't specifically stated. Similarly, there's analogous grounds like criminal record that's not explicitly stated here, but has been held to be protected by human rights. To be successful in a claim of discrimination, a complainant will have to prove that they have a protected characteristic, that they experienced adverse treatment in employment, and that the protected characteristic was at least a factor in that treatment, and that the employer did not have a bona fide reason for doing so. The duty to accommodate refers to the legal requirement for employers to make reasonable adjustments, ensuring that nobody competes at a disadvantage due to any of the protected grounds of discrimination. While the duty to accommodate is best done on a case-by-case basis, some examples could be providing accessible facilities, flexible work hours, or modifying job duties. Human rights recognizes that the duty to accommodate is not limitless, and if it can be shown that providing accommodation would pose undue hardship, accommodation may no longer be required. It's against the law to take any retaliatory actions against employees in exercising any of their legal rights. This is the case whether or not a formal complaint has been made or whether an informal issue has arisen. Reprisals can take many forms. It's important to be aware of what's happening in your employment, and if you suspect that you have been retaliated against, you should contact Human Rights Commission or make a complaint through your workplace. Unfortunately, retaliation in employment is far too common. Recent research by those in Western University, University of Toronto, and the Canadian Labour Congress examined all types of workplaces across Canada through surveys and interviews and found that a significant portion of workers who experienced harassment and discrimination were subsequently retaliated against by various methods. If you feel that you may have been discriminated against in employment or retaliated, contact the Manitoba Human Rights Commission. You can also contact CLIA and search the website for its helpful information on anything related to human rights and employment.